The court further said that the first paragraph of the section speaks of something which is impossible inherently or by its very nature, and no one can obviously be directed to perform such an act. This is the reference to a void agreement in the first part of section 56, which says that an agreement which promises to do an impossible act, the agreement itself is void. That is the first paragraph. So the first paragraph of the section speaks of something which is impossible inherently or by its very nature, and no one can obviously be directed to perform such an act. The second paragraph enunciates the law relating to discharge of contract by reason of supervening impossibility or illegality of the promised act, of the act agreed to be done. So if that act becomes impossible or illegal by supervening circumstances, then the contract gets discharged. This is what the second paragraph of section 56 says. The word impossible has not been used here in the sense of physical or literal impossibility. Section 56 comes into play when the promised act becomes impossible. What is the meaning of this word impossible as it appears in section 56? The Supreme Court says that it does not mean physical or literal impossibility. It is not that the act is physically impossible to do. That is not the requirement of section 56. So then, what is the requirement? What is meant by impossible? Performance of an act may not be literally impossible, but it may be impracticable and useless from the point of view of the object and purpose which the parties had in view. So what is to be seen is the object and purpose of the contract, and if the promised act has now become useless or impracticable with reference to the object and purpose of the parties, then we will say the act has become impossible. Though physically it may be possible, but now it has become useless or impracticable, and therefore it will still be termed as impossible.